Hi, Amy.
Thank you. Sorry, I had two different things up. How's re-entry after the Bahamas?
I've been so busy with this, it's just like a distant memory now, but a very fond one.
Good, I'm glad.
We were out by the pool one day when the clouds rolled in and it
Hmm.
just bucketed down rain and the wind was blowing and it lasted for about 5 or 10 minutes and it was gone, but it was a thorough soaking.
It is it's crazy when those storms roll in because you're just like, where did this come from and how long is it going to last?
Yeah.
Sorry, we have people still rolling in. I just got a Teams message. Did anyone get a Teams message from me about setting up a meeting?
So I noticed in the invite that it had in the subject line, it had the Zoom invite, and then it had below that in the body, it had the Zoom invite, but then way down below that, it actually had a Teams meeting invite.
Okay,
And so it might be that some people might see it on their like on my calendar, it has like a little join button, and I pressed that, and it took me to a Teams meeting, so I got
that is a
off. I
that
got
is a
off
new
and
one.
got on here. Yeah.
Thank you. I will go join that one and see what's going on. I'm not sure why that happened, but I will be I'm going to mute myself and see if I can fix that. That's very odd. Thank you.
Good afternoon.
We'll just wait a few more minutes to resolve the Teams meeting conflict going on here.
Okay, I think I talked to the folks over there, it was only one. And I think we're good. But I will keep an eye on it. Sorry about that. I don't know why that populated like that.
Amy, while you were gone, I got Teams pop-up saying that both Valerie and Linda Hukari were in the Teams meeting. Oh, there's Valerie.
Valerie's here and I just talked to Linda.
Okay, great.
Too many venues to have these meetings.
Teams likes to make sure that they're on top.
That's so true.
So the flow of folks have stopped. So Krista, in just a second, I think we can start.
Okay, well, welcome everyone to our last regularly scheduled work group meeting. Appreciate you all taking the time to be here again and for all of the work that's been going on behind the scenes. And I want to just welcome Valerie Sasaki to our meeting, and she is the chair of the Law Commission, the full Law Commission. Valerie, did you want to say anything to the group?
Yeah, so I asked that Amy include me on the invitation for this meeting because I know it is your last regularly scheduled meeting for this work group process. Because I just wanted to thank you all for all of your hard work. I know this has been quite a heavy lift. And I really appreciate everybody's thoughtful deliberation and hard work in what I think is a really challenging topic. You know, I'm very excited that we're going to be able to have a good work product to introduce in the next legislative session. And then, you know, continue discussions as appropriate. I know that this group has had some thoughts about sort of what the next step for this project may look like. But I wanted to come on and acknowledge all of your hard work, acknowledge the hard work of Justice Duncan and Krista and leading this group, and just say that I'm really impressed with most of the most of the projects that the Law Commission does. We have a model act to start with, and you didn't have that. So I think that made the whole process that much more difficult. So looking at where this group started and where it is now, I have been very impressed with all of your hard work. In an area that I know, frankly, nothing about. So thank you. Thank you for all of your hard work. Thank you for your time. And thank you so much for helping us make the state legal position better. So that's all I had to say.
Thank you, Valerie. Thanks for taking the time to be here. And I wanted to follow up with again my deep gratitude for the last few weeks in particular. There's been a ton of work going on, and I particularly just want to appreciate Justice Duncan and Jim and Jessica and Amy working many hours over the last few weeks to get the working draft 6 out, as well as the draft report that you have. And all of you who have also continued to review those materials and send us emails and help us to continue to edit it and make it as clean and clear as we can going into the to get it ready to give to the Law Commission. So we are very close, I think, to a final product here. And as far as the draft bill, as far as timelines, we need to finalize what gets submitted for editing by Legislative Council so that the Law Commission has an edited version from Legislative Council that is in the most final form possible to consider for their December meeting. And then after that, there's some flexibility for additional edits to be made to the bill if needed. But we are on a very tight timeline. All changes by this group for the draft bill that's going to go to the Law Commission for consideration in their December meeting need to be made by tomorrow so that the bill can go to Legislative Council for editing by Friday. And then there will be editing by legislative council of this group's work, both for clarity and to make it conform to legislative drafting principles. So there will be some changes that occur in that editing process. And Jessica has said she'll be keeping track of those changes. And so we can notify the group of what those are. And of course, if any wording changes result in something that was not intended, we can get those fixed. It's not the end of the road there. And then we do have a little more time to finalize the draft of the report that will go to the Law Commission. That this group needs to make any changes by the 20th so that it can be sent out to the full commission by the 21st. So I imagine this is, I mean, these timelines are very tight. I recognize that, and I recognize there's a lot to review. Hopefully, because we have been reviewing things on a rolling basis, I hope there haven't been too many things in the newest draft to look at. And we have a number of just clarifying things that Jim and Justice Duncan and Jessica have noted over the last few weeks, and others also have sent in some comments. And so I want to go through those today and just make sure that we're all on the same page on a few things. And if there are any other things that people feel like the full group needs to talk about, we will do what we can on time today for that. But there, again, basically we need to receive by tomorrow any changes to the draft bill that you would like to have done for this round of review by the commission. And again, you know, after that first round, if there's other things that we realize need to be changed, we'll deal with that.
And Krista, may I add one thing?
Yeah.
So one of the things too that we've experienced with the LLC bill, and that, you know, Amy and I have talked about, because I understand there's some areas that have policy questions that are involved, that the legislature may want to weigh in on, and how we're choosing to address those for LLC, which I think is is probably a reasonable approach, is by incorporating some discussion of the pros and cons of different policy positions within the report that's going to accompany the bill, because I think that's going to be the tool that we're going to use to help legislative staff understand, you know, the discussions and the hard work that folks have done and understand what the final work product looks like. So, you know, and that is something that Amy and I have talked with former Representative Shutterly about. You know, it is something that has some precedent within the Laws Commission approach. So to the extent that there are policy discussions that need to continue after we get those comments in on the core bill, you know, that we can continue that policy discussion and, you know, memorialize it to some degree within the report. So I just wanted to mention that because that's going to be sort of an ongoing discussion point.
And I think you'll definitely, if you haven't already seen in the report, some of the things that we would have liked to have gotten to, the policy questions we would have liked to have gotten to and would have liked to have been able to work on consensus for, and we haven't had time to reach the consensus for them. And so recommendations for the work group to continue its work after this legislative session on those sorts of things.
Fantastic. Yeah, and I think that's a really great approach to this. You know, I think it's really important that we get a bill out this session, though, you know, at least get it into the legislature for consideration, because you have worked too long and too hard on this, and your work has been so exemplary on this whole project that I want to make sure that we're able to put a flag in the sand, and then we can keep moving the discussion forward.
So with that introduction, are there any clarifying questions about what our process is here at the moment?
I'm not sure if there's a hand raise feature. I'm not seeing it. So anyway, I'm just kind of curious. So a couple of things. One is on the report, I'm in the process of going through, and our team is looking at the report. I have like some things that are just like little typos, or some things where I think like some additional clarification would be needed. where do you want us to send those? Do we want those to go to the whole group, or should I just send them to Amy and she can distribute, or like, I don't know. I know we're short on time, so wanted to figure out like the best way to get that to
Yeah, I
you all.
appreciate that question. I think at this point, the best thing to do would be to send them to Amy, and then we will collate those things for the draft report. And I'm sure that there will be some overlap, and then we can, the things that are clearly just clarifying edits, we'll just make those. If there's things that need to go to the large group, then we will send out, messages to the large group. So yeah, please send any comments to Amy and or me, that's fine, and Justice Duncan, but Amy is going to be the sort of the central hub and for those things in the coming few days here. Any other questions? Okay, thank you. I have, as well as what was listed in the agenda, which were the questions that we knew at the time we sent out the agenda, we've come up with a few more questions in our review process of the drafts. And so I'm going to just go through the in order of section, and for those of you who have sent in questions, your questions should be in my list, and if they haven't shown up by the end, then let us know. So the first one is in section 3. And the question is, there's some distinctions in the draft currently about the case record provisions between the justice and municipal courts. And Jessica, do you want to talk about what your plan is on those and see if we have agreement on that?
Sure. So section 3 is the case record provision for justice courts, and then section 52 is an amendment to ORS 221352, which is the same for municipal courts. And it was noted that there are differences between these two. So section 3 is based on current law, but there is some updating and rewriting of those provisions. And then section 52 has a few things that section 3 does not, because section 3 has a few more general catch-all provisions. So my plan for making these harmonize was to basically to section 3 add a couple of the specific things that section 52 has, but also in section 52 use a couple of the more general phrasings and the updated phrasings that we have in section 3. So there could be a risk of over-inclusiveness, but I don't think that is like a terrible thing to risk at this point. And this would appear in the version that would go in for editing. And obviously, if people had feedback about that, it would be welcome. But that was my plan to harmonize these two sections going forward.
Are there any questions or comments or concerns about that proposal? All right. And obviously, we have another day here. So if you want to process any of the things that we're discussing and give us feedback within the next 24 hours, you're more than welcome to do that. Hearing nothing at the moment, though, I'm going to move on to the next section. And that is section 4. And Judge Brisbane sent in a comment that there is a concern that we should revert to the current law language about using justice of the peace rather than clerk as the repository of the case records. And Justice Brisbane, would you like to explain that a little bit more?
Okay, thank you. The Justice of the Peace is an elected official who is a department director in charge of court operations and also staffing. And the Justice of the Peace should have the power to delegate that job. In my situation, it would be a designated clerk, but I would be overseeing it as the current law stands. If we don't amend it to the language in section 4, the Justice of the Peace would remain in charge of the files. They can delegate that to the clerk, mean, the clerks have no power unless the elected official delegates that job to them. So if you're looking at, for example, the only reason that clerks can adjudicate cases at the window or over the phone with violators on traffic offenses is because the Justice of the Peace has delegated a person to be the violations clerk, and that's by statute 153.800. So following that, the Justice of the Peace really is the person that is the designated person in charge of the court operations and staffing. In my case, it would be delegated to a clerk, but it would be overseen by myself, and also technology, because we don't have any paper files. So giving the power to the clerk bypasses the job of the Justice of the Peace.
And that would be the current language. We had just
Changed
for
it.
the statute, we changed it because we were thinking that the group had thought maybe that was kind of modernizing it, but it seems like maybe that's unnecessary and not particularly helpful. Are there any other comments or questions, concerns about reverting back to the Justice of the Peace rather than the changed clerk language?
I totally agree with Judge Brisbane, and there are also some justice courts where the Justice of the Peace also really serves as the court clerk as well. And so, because they don't have a staff per se. So I think reverting back to the current language is also rather important, perhaps for some of those really small operations.
Okay, I'm hearing no objections to that, so I think we'll do that and move forward. The next section we have on our list is section 10A. And there's a need to clarify, and I think that this group may have talked about this at some point, but it's not currently reflected. In the filing fees, we need to clarify if there's a misdemeanor charge attached to a violation, that it's treated as a misdemeanor case for purposes of the filing fee, i.e. no fee in those cases. I think that was the intent of the group previously. If that's accurate, we'll make sure that the draft bill states that clearly. Any questions or concerns on that?
I think that subsection 1A of section 10A does say that it's on appeal from a justice court to the circuit court in a civil action or an action for the commission of a violation. So I think maybe it has that scope already drafted in.
We discussed maybe adding only to that paragraph. So in an action for commission of, it wouldn't exactly be these words, but that contains only a violation, just to resolve that possible ambiguity.
Oh, I see. So if, in case it has a violation and a misdemeanor, to not, okay.
So I guess that approach worries me because it's actually ORS 21.135 that imposes the duty to pay the filing fee, and that statute does not distinguish between those actions where it's only a violation and those actions where it's both a violation and a misdemeanor both. So I think we may have to tweak the wording of ORS 21.165 if that's what we're going to do.
I think we can probably let Jessica and legislative counsel take a look at that and figure out what needs to be done. But if the intent of the group is clear that if there's both misdemeanors and a violation, the case is treated as a misdemeanor for filing fee purposes.
Yeah.
Okay, hearing no opposition to that, move on to the next section. Section 14. In going through this, we thought that subsection 5 of that probably is unnecessary and should be deleted. And it's confusing. And I don't know if anyone else wanted to say more about that.
Well, it worries me that when these stays are granted and then nothing ever happens to it. It seems to me that you have to have either a stay ceasing by operation of law or impose either a duty or at least authorize the parties to move for vacating the stay or changing the stay. It just worries me that it just hangs out there.
I think the idea is that once the case is remanded or finally decided, then the court that's making the decision would make a decision what to do about the stay if it weren't already in the stay order to begin with, because often stay orders just say that it's until a condition precedent, essentially, and then it would automatically do its own thing. And the problem, I guess, with an automatic vacation would be potentially a notice issue, maybe.
Well, I guess I could live with deleting subsection 5 then.
Would anyone else like to comment on that at this point? Okay, let's move on, and again, if you have more thoughts afterwards, let us know. But as it is, I think we'll go ahead and delete subsection 5. Moving on to section 21. In reviewing this, it seemed unclear about whether as written, it really addressed the full scope of stays that were intended or not. And in reviewing it, we thought perhaps the best way of dealing with this would be to, so as it is, subsection 1 addresses misdemeanors and subsection 2 addresses violations, but the subsection 2 is very general, while subsection 1 is very specific. And so we thought that if we would make subsection 2 address both misdemeanors and violations and move that to be subsection 1, and so that would be sort of a general catch-all provision about the authority for stays, and then subsection 2 the new subsection 2, which is currently subsection 1, about misdemeanors would be sort of limiting conditions on misdemeanors specifically. Thoughts or comments on that?
I guess what bothers me is that I believe the parts of section 21 are almost verbatim taken from current law, and the work group didn't have the time and opportunity to think about alternative ways to phrase the same thing, and so I'm a little bit reluctant on the fly to make those changes now. Especially because I think if the commission authorizes the work group to continue its work, this is an area that I think needs a lot of work. It needs a lot more work. And that I would hope that we would come up with a more comprehensive set of changes in the future. So I'm a little bit hesitant to kind of change the law now.
I don't know that we're changing the law. I think what we did was put 2 provisions into from different sources into section 21. And the worry with current section 21 is it looks like for misdemeanors, the only types of times you can get a stay are 1A and 1B, which would be when you're confined or if you've committed a traffic crime. So it wouldn't cover fines in other cases involving misdemeanors. And so the worry is that with these two provisions together, it's going to look like you can't get a stay in all the circumstances where you can under current law. is the worry.
And so would the idea be then to reword subsection one? Because otherwise, if you don't, I think you still have that same problem. I think
So
because it's saying it does not stay the enforcement of judgment unless would be like, it would say that seems to contradict. If I don't know
right,
if you,
it would be something like if you're confined, like if current subsection 2 becomes subsection 1, it just says there's no automatic stay, but the justice or circuit court could stay the proceedings. That would be the rule that would apply to violations and misdemeanors, and we would be retaining in this what is now 1, but would become 2, these current statutory limits, which say you can't get a stay if you're confined unless this, and you can't get a stay in a traffic crime unless this. So I think the substance of the current law would remain, but we would have to phrase it so that what's currently in 1A would be clear that those are special requirements that have to be met in those types of cases to get stays, and those are the requirements under current. We just don't want people thinking that you can only get a stay if you're either confined or you've committed a traffic crime, because I don't think that is current law.
Guess I would withhold judgment until I saw the new wording.
Yeah, I think that might be, would it solve the issue if we simply added in subsection 1, a paragraph C, that would be, so be A, B, or C, upon motion to the court. So that it's clear that there is an option to make that request outside of these two other areas.
I think that's what we were trying to do with the suggestion. So I guess maybe if we just back up and get a sense of whether people are okay with the idea that in both misdemeanors and violations, you can request a stay and the justice or circuit court can grant it. That's like one idea. But then the next idea is there are limitations on stays in these two particular types of cases, and we would be maintaining those limitations.
so you'd
People-
probably need to word sub C as something in like in all other cases on motion of the defendant or in the court's own motion. I don't know how that works.
I guess conceptually, are people okay with the idea that you can have a motion for a stay in a violation or a misdemeanor case and that either the justice or circuit court can grant that? I think people are. And then the next question is, but we still want to retain these limits. And if people are okay with that, then we can wordsmith the section
What
20.
I'm confused there, Justice, is you say either the justice court or the circuit court could grant the stay? Because it seems odd to have that ability in either court. I mean, which you seem should be with one or the other, shouldn't it?
Well, I know when you have an appeal from a circuit court to the Court of Appeals, you can file your stay in either court. And in fact, people will often request it in their trial court and then request, if they're denied, request it in the Court of Appeals. So this would parallel that structure, which
Actually, I'm not sure that's true. If you all haven't looked at ORS 138.285, you should. That is a very thorough and comprehensive statute that addresses stays on appeal to the Court of Appeals from Justice and Municipal Courts of Record and Circuit Court, quote unquote, in criminal actions in ORS 131.005. That's important because 131.005 defines criminal actions to include felonies, misdemeanors, and violations. So that statute actually governs stays on appeal from those courts to the Court of Appeals in violation cases, even though under current law, violation cases generally go under Chapter 19, applied to civil cases. That statute 138-285 was enacted as a freestanding statute by the legislature and merely placed in Chapter 138 by the Legislative Council. And also, I would note that statute that says it only the local court of record or the circuit court may grant a stay. It does not authorize the appellate court either to grant a stay or to review the trial court's disposition of a motion for stay.
And also, Jim, I think creates a requirement that it be filed, the request for the stay be filed at the time of the notice of appeal. Is that right? And there one,
I have not focused on that.
no, I'm just saying, but in terms of I'm looking at the reading the statute as you tell me to read it, so I'm not pulling it out and reading it. I follow your directions implicitly. So I think you're right that this does cover this circumstance. And it will be filed in the trial court at the time of the notice of appeal. And it says the trial court retains jurisdiction to enter an order under this section, irrespective of whether a notice of appeal has been filed. And it also talks about the conditions that can be imposed and sets out all sorts of criteria to consider and so on.
One alternative we discussed that I would just throw out to the group is adding a provision to section 21 that just says nothing in this section is intended to affect the authority of the court to enter a stay under any other statute or any other authority, something along those lines.
Yeah, I think that would work because I'm uncertain whether there's any statutory authority for a local court to grant a stay in a violation case other than perhaps a court's inherent authority. But if there is such a statute, then your wording would certainly cover it.
Lindsay, did you have a comment?
Yeah, my comment is on a little bit of a tangential issue, but it does have to do with the timing. I was just curious if we wanted to include something on the timing for that motion in subsection 2 as it's currently written. It just said on motion of the defendant or on the court's own motion may stay, and there's no time requirement there. So if the group does want to impose a time requirement, it should probably be referred to there.
And that timeline should probably reflect the 138.285 timeline that it be filed at the time of the notice of appeal, because otherwise you're going to have two statutes in conflict.
I'm a little bit uncertain about that. In civil cases, I know that oftentimes the motion for stay or a supersedeas undertaking is not filed until sometime later when the judgment creditor attempts to enforce the judgment. It's not always taken care of at the time the notice of appeal is filed. I don't know whether in criminal cases, let's say that a defendant was on probation when the notice of appeal was filed, and then during the pendency of the appeal, probation gets revoked and the person is then in custody, whether it would be appropriate that the defendant could move for a stay at that time.
Well, if we're going to amend 138.285, I think that's a whole different can of worms, Jim. And I think that's what, to cover what you're talking about, I think that's what would be required.
Well, that's what I'm saying, that this that we're spending a ton of time at the very end of our processes on this one issue, and it really is something that the newly constituted work group needs to look at, because there are a lot of facets to it. And so I think we ought to do the bare minimum here, preserving existing law as best we can, and leave it to this work group in the future to iron out all these details.
I think that's a good idea. And so does Jessica's suggestion about adding something that says that it's not intended to change, however you said it, not intended to change any other source of law for the state, and also putting something in the report that just says we're intending to keep current law. Does that resolve the issue?
Yes.
Okay, I appreciate the discussion on this, and you can continue to chew on that and let us know if you have further thoughts on that. The next section we have let's see. Section 24. Let's see, Jim, you had raised a question about whether section 24 sub 1, although it's currently verbatim of current law, ORS 53.010, it leaves out judgments for the recovery of a penalty or forfeiture, and it's ambiguous that it even includes judgments for the money or damages. Subsection 1 should read, any party to a judgment conclusively disposing of an action described in section 2 of this act, other than a judgment by confession or for want of an answer, may appeal from the judgment.
Yes. I don't know why the current statute is phrased the way it is, so I'm a little bit reluctant to change it. So maybe we just leave it the way it is. But it just is strange the way it's worded, because it leaves out some of the types of cases that justice courts have jurisdiction to rule on. Maybe this is one that our justice court members can take a look at in the next day or two and get back to us to whether they think the current law is, and the way the current bill is written is fine, or whether it needs to be tweaked.
Wasn't this the language specific to small claims, or am I mistaken in that?
No, I think it's taken from chapter 53 that addresses appeals and civil cases generally.
Yeah, I'll be happy to take a look and see. I think I'm sure Judge Brisbane will do the same. I just volunteer you, Judge Brisbane.
And then I think another portion of that is a question of there's an additional part of ORS 53.010 that was omitted here that says, or when the action is for the recovery of personal property of the value of not less than $30 exclusive of disbursements in either case. So whether we need that as well in there. Are there any more comments right at the moment on those? Okay, let's move on to section 35. We just want to verify that that folks are okay with the the repeal of ORS 55.120 means that the deadline for undertakings for small claims will be the same as for other civil appeals, which means, my understanding is that means 5 days after the notice of appeal is filed rather than at the time of the filing of the notice of appeal. Did I get that question accurately phrased there? And I guess the question is, we just want to make sure that that was clear, and if anybody does have any concerns with that being the same for small claims as for other civil cases. Okay. We'll move on to section 43 and wanting to verify the intent there that by inserting section 43, which is new, I mean, it's been in our working draft, but it's a new provision, and its intent is to abrogate specific case law. And I'm trying to, it's on the agenda, City of Staten versus Wilson. And that's regarding the writ of review not applying to municipal courts, and section 43 makes it the same as for justice courts applying it. And we wanted to check with the group and make sure that was an intentional act, which we thought it was, but double checking here.
Well, I'm kind of a little fuzzy about the current status of that case law, because after that case law, you get Mylander in 86, which says that at least when municipal courts are hearing state offenses, they're acting as justice courts. And then you have Milton Freewater versus Ashley in 2007, which sort of confirms that a lot of the justice court statutes apply to municipal courts in the state violation cases through that reasoning. So I guess it's a little fuzzy to me whether some of that earlier Court of Appeals case law is still good law, at least in cases concerning state violations as opposed to municipal ordinances. That's just a point of confusion I had on this, and we might not be changing current law that much.
So perhaps the question is, regardless of what current law is the intent that it be the same for municipal courts, the writs be the same for municipal courts as they are for justice courts.
I don't see any reason that they should be treated differently, and the cases where that distinction was made didn't provide a lot of analysis either. So I don't see why they shouldn't be consistent.
It's somewhat unclear to me to what extent people actually use writs of review. And that's sort of an area of mystery to me. Kind of generally, I've never been able to figure out if it's a thing that should exist or if people actually use, but I don't really have strong feelings on it as a consequence.
I've never seen one in 15 years.
I think the distinction here was just in criminal cases, right? Because I know that in municipal court, there are writs of review for like administrative matters like impoundments or animal impoundments, park exclusions, things like that. So I was understanding this to just be for criminal, and I don't know what they're used for exactly, but yeah.
Okay, it doesn't sound like we have any concern with making them the same. So we'll stick with what we've had in the draft bill. And the last thing on my list is just to check with you all as far as the report and how to list the participants in the report. We discussed whether we would include affiliations for people or not. And I know some people are here not on behalf of their employer. So we were thinking of not listing people's employers, but listing people's names and then including a section that describes in general the sorts of experience and backgrounds that people brought to this group so that it's evident in the report what kinds of backgrounds there were. Does anyone have any comments on that?
I guess I would prefer to be associated with my employer. And for those people who are here who are not associated with an employer, then just maybe put something indicating in their, in their individual capacity or something like that. Um, I, I think that that's more useful for folks who are looking at the report to understand, like Kimberly McCullough wasn't just there on her own, giving her own opinions, but she was there representing OJD. Um, I also had a question. This may be a little bit of a diversion, so sorry if I'm taking this a different direction, but just sort of about how the participation is going to be sort of portrayed either in the report or to the legislature as far as, is this work product sort of going to be portrayed as a consensus of the group, or that the work product is the Oregon Law Commission's proposal that has been informed by the sort of like technical advice and opinions of this group. Because for those of us from OJD, because we don't really take positions on the policy, and really are just here for the technical, and there are some policy changes here, just wanting to make sure that that's kind of clear as well. So that sort of has to do with our affiliations as well, but sorry to take you down a rabbit hole.
No, that's a great question. And I think that it is a commission bill, and there's been a lot of participation by a wide variety of people. We've worked for consensus in order to have a bill that everyone can buy into, and it's not we haven't had a formal voting process or anything like that. So it is informing the commission as they vote on the bill, essentially. Anyone like to add clarification to that?
Well, and I'll weigh in on this too, because this question comes up whenever we have a project. So when we've done other projects that of course have folks from OGD or Secretary of State or Revenue, there's a lot of spirited discussion that happens in these meetings that is, memorialized in the recordings. But typically the questions that we're asked are, when the legislature is considering the bill is, what was the deliberative process? Did you have the right people around the table? Did everybody have a chance to discuss the issues that they were concerned about? There may be things that people don't agree on entirely, that for purposes of moving the bill forward and making sure the perfect is not the enemy of the good, right? We want to make sure that, we memorialize the fact that we had discussions on difficult things, but not that Kimberly, said these things on behalf of OJD, because I think that's counterproductive, right? What the legislature cares about is they care about whether we've had the opportunity to really think through the tough issues and that we had the right people around the table. So, so I think that you've certainly got the right people around the table here. And the report will memorialize where maybe there was some disagreement about things that we decided to move forward on, or here's some issues that are going to be addressed in future work groups where we think there's opportunities for future discussion. But it doesn't ever get as granular as, oh, everybody, this is the position of everybody who ever touched this thing, right? Which I think is a reasonable concern for folks who are involved on the government side. But we do really appreciate your feedback. And part of having these work groups is to make sure that folks who, have expertise have a chance to weigh in and share that expertise on these issues that are so important to our state.
Right, the work couldn't happen without the
Right.
participation of everyone here. So
Yeah.
if it were me and Justice Duncan doing it, it would never have happened. So
Krista, I'm seeing in the chat a lot of people saying that they'd like their business, their official affiliation listed in the report. And it seems like we could do that. I know some people, like if we were to put your employer, you're not here on behalf of your employer, but it looks, I'm wondering if people want us to list their employers, or it looks like some folks do.
Why don't we just, as opposed to trying to capture what's in the chat, why don't we just have folks who care to have their organization as, listed in the report, send that to Amy.
maybe if everyone could let us
one
know
way or the other. Yeah.
how they'd like to be listed in there.
Yeah.
At least if it's something different than what we already have in there.
You want that as an email? Is that what you're suggesting?
Yes, please.
Well, sorry I'm late to the meeting, but in order to give some feedback from ODAA, we're actually meeting on this bill tomorrow. We're happy to provide feedback on it at that point. It has been, as of received on Monday, it has been kind of sent out to some parties, but it will go out to more today, and we'll have more information for you about our specific concerns.
Okay, since you weren't here at the beginning of the meeting, I want to just make sure that I go over the timelines again. Since Legislative Council needs, we're giving them the bare minimum amount of time to do the editing of this bill before we get it to the commission for the December meeting. And so Jessica needs to have everything, all the comments by tomorrow in order to get the bill into editing, the formal editing process by Friday. So we are on an extremely tight timeline. And on the report, we have a little more time since we don't have to go through that formal editing process. So we need to have all the comments up by the 20th on the report. And so it can go out to the Law Commission on the 21st. Now, that doesn't mean that after the Law Commission looks at this, that there won't be any opportunity to make any further changes if we figure out that, there's drafting errors or unintentional, glitches, whatever. We can still figure that out later. But for the draft to get to the Law Commission, we're going to have any more comments on the bill by tomorrow. So I'm glad it sounds like your meeting will coincide with that. And that's all I had on the agenda. Are there any other things that people felt needed to be raised in this group?
Krista, I sent over just before this meeting some questions that we had, and I don't know if when we were running out of time today to discuss them, so that's fine. Maybe they could just be added to the list of feedback that's coming in, and it might be some questions that we can just easily answer via email. I just wanted to flag that.
I am not seeing that. Did that?
Krista, it came to me and I forwarded it to you and Justice Duncan at I think like 12:01.
Okay. I'm wondering if we have a few minutes, are there things that need to go to the full group here? Let's try and hit them if there are.
So my first question has to do with the filing fee, or whether there is a filing fee when it comes to transferring a violation case under Section 5. So the work group came up with this idea of a transfer instead of the conditional plea. But thinking about it a little bit more, it occurred to me that there would be a filing fee if a defendant was appealing from a conditional plea. And in this transfer provision, it doesn't reflect whether or not there would be a filing fee. So that was just a question that I had about the intent. And maybe either way, it would benefit from some clarity on whether or not a fee is required in that circumstance.
So
I don't think
certainly,
there should ever be a filing fee with out of a misdemeanor conviction, or even a ruling before a conviction.
And I think it would apply only to the violations.
Yeah, and the way the bill is structured, we are amending ORS Chapter 157 with respect, basically barring conditional pleas. ORS Chapter 157 only applies to misdemeanor cases and does not apply to violation cases. And so since there's no filing fee for misdemeanor cases, there shouldn't be a filing fee for those transfers in misdemeanor cases that take the place of a conditional plea.
So subsection 2 of section 5 says that this transfer applies to a violation or a misdemeanor. So was the intent to only apply those transfers to misdemeanors? And if that's the case, then maybe we just would remove violation from that subsection.
That was my intention, at least, is that this was a misdemeanor specific provision. I didn't realize that violation was in there.
Okay, so I think in that case, just removing violation would answer the question and remedy the issue. So that's section 5, subsection 2 in the second line.
Well, thank
There,
you.
we got one of them done.
Thank you. Thank you. Okay.
Wait, so
second-
can I ask a question? So are we saying then that this transfer option wouldn't be available for violations? That seems like a big change from how it's currently drafted.
That is what they're saying, and saying that that was the intention, or at least some of their intention.
Yeah. I don't know. I mean, it was a while ago we had this conversation, and I know misdemeanors were a focal point, but I'm not sure that we didn't mean for it to be in there. And if we're just intending to like resolve a fee issue, I would be more inclined to just do that now rather than assume that a pretty substantive like part of this provision was a mistake at this point. Because I do remember us having conversations about whether, you know, if like both parties agree to a transfer and there's no point in keeping it in the court, and like some of the policy considerations. And it's not clear in my mind at this moment that those discussions weren't also dealing with violations, because I would think the same considerations would apply there. So I would vote for just resolving that fee issue rather than making a big substantive change here now.
And Heather, that
Yeah,
resolution would say,
I'm thinking that might make sense because even though ORS Chapter 157 on its face only applies to misdemeanor cases, there's also the provision applicable to violation cases that says all of the rules that govern criminal cases generally apply in violation cases except as otherwise provided in that chapter. So I guess in that roundabout way, conditional pleas could be applicable in violation cases. So it probably makes more sense just to resolve the filing fee issue. And my personal preference is that there wouldn't be a filing fee for it, but others may have a different view.
We debated that a long time, Jim, and the filing fees were decided to remain.
That was for an appeal, not a transfer. So there could be a question about whether it would be the same. Not to open the can of worms, but I see why it's not resolved with it, because the bill does currently have a filing fee for violations, but here we're talking about a transfer, and I think that's why it's not clear.
I'm not sure that circuit court would be very, very fond of transferring it without any kind of a filing fee associated with it, especially because essentially it is an appeal. And it's an odd appeal because it's a pretrial, it's appeal on a pretrial ruling. But I think the fees would have to be associated with it. And so if that's the case, we should make that make that clear. Also, I'll point out that the provision is it requires the agreement of the defendant, the prosecution, and the court. All three is my understanding.
I'll just note that realistically, this isn't going to come up a lot in violation cases. Like we're mostly dealing here with motions to suppress and misdemeanor cases. So, I mean, whichever way we jump on the fee issue, the number of these transfers is going to be very, very small in violation cases and very small in misdemeanor cases, even, I think.
But that would the existence of this, the way it's written, then impose a requirement upon the judicial officer to inform the defendant that the statute exists and that they have this potential ability to seek this transfer.
I don't think so.
I don't think so, by the way, but because it's not like the same thing as the right to appeal, which should be explained in detail. But.
Well, let's sit on that for a minute here. I'm wondering if we can stay on a few more minutes and try and go through Lindsay's list so that we have as much discussion as possible. And I guess we'll just have to communicate to those who aren't able to stay in an email subsequently. Can we move on, Lindsay, to the next question that you think should be discussed with the group?
Sure, thank you. So the second question is also about filing fees, and I think I understand the intent, but I just want to make sure. Section 10A talks about the filing fee and that the notice of appeal is filed in the local court. And I just wanted to clarify my understanding that if the defendant or the appellant includes a fee waiver or deferral application, and that's forwarded to the circuit court along with the local court record, but that application is denied, what the court would do with that record. Currently, ORS 21-100 requires filing. If there is a filing fee, it has to accompany the filing that has the fee, otherwise the case can't be initiated. So my understanding is that in those circumstances, what the court would do is then just send the record back, not initiate a new case, not initiate an appeal in the circuit court, and send the record back to the local court. But I just wanted to make sure that that's clear, that it wouldn't be like a dismissal or something like that. It would be an outright just not acceptance of the record. Is that correct?
I think that's right. And I think the piece that we've left out is what the local court then does with the appeal. And perhaps we should make it clear that the local court would have the duty to inform the appellant that the circuit court denied the motion and that the appeal has not been filed.
And just to clarify, I think that the circuit court would correspond with the appellant. It would just be in like a pre-filing kind of posture, rather than having already accepted and initiated the appeal in the circuit court. So I don't know if there's anything we need to add to the statute. Maybe clarification in the report might be appropriate, but I was just also wanted to make sure I had a clear understanding of the intent and that the intent wasn't contrary to that.
I think that the idea of putting it in the report is okay because current law doesn't explicitly address it either, and it seems to function as is. So if that makes sense to everyone, we can just add it to the report.
And I think what would happen with regard, just procedurally speaking, if there's a motion for deferral or waiver of the filing fee, I think essentially the justice court then has to send that over to the circuit court. We just simply note that paperwork was filed on this date, and you wait the ruling from the circuit court with regard to the waiver. If that's denied, well, then obviously then there's not. The question is at that point in time, there's not a timely filing of a notice of appeal, and therefore there would be no appeal. That's the way I read what is currently written here. Folks may think I'm wrong. I don't know. I'm open.
I do think that currently many courts would give the appellant the opportunity to pay the fee if the person wants to go ahead and pay the filing fee if their application was denied. So I think there would be that opportunity. And then if the filing fee was not paid is when the case would not be initiated.
Not the way it's written, though. I mean, if you're gonna pay the filing fee right now, it has to be at the time you file the notice of appeal. You have to do that within the 30-day period. So if the circuit court denies you, and you're past the 30 days, I don't think you've perfected the filing, and I think the Justice Court would have to reject the appeal. I mean, so it's potentially a big issue here under this current language.
I think that was definitely not the intent.
I don't think it was either.
And to my knowledge, current law doesn't address that either. And it's, you know, as Lindsay said, the process is generally to allow payment of fee.
I remember us discussing this too as a group, and you know, that practice that if a motion or an application is denied, that parties are generally given an opportunity to then proceed to pay the filing fee. And so if folks agree that it's not clear here, maybe I think our intent was that that would be allowed, and so maybe it could be clarified.
Perhaps language could be added to say that if the request for the waiver is denied by the circuit court, the appellant has, 5 days, 10 days, whatever it may be, to post the fees with the Justice Court. But I think if that's what we want, then I think that should probably be spelled out.
I do think at that point, though, the appellant could just pay the circuit court since it would have been forwarded to the circuit court. So I'm a little hesitant to put a time period in there. I would have to check with I would like to check with our circuit courts just to see how that works in practice at the moment. But there'd need to be some correspondence back and forth. So
I think that's perfectly logical, but because the appeal is filed in the Justice Court, and part of the filing to actually have the it perfected, the fees need to be either posted with that or waived. So that's, I think, while what you're saying makes sense, I don't think that's currently the way it's set up, and I think there'd be a problem with that logistically.
Lindsay, would you be willing to look into a little bit more what current practice and law are, and we'll, as the leadership will look into it as well and see what we can come up with. But I think we all understand or have the same idea of the intent here.
Sure. Yeah, no problem. And so then my last two are just some other questions that I had about potential collateral consequences of the kind of wording changes or the drafting choices, in the bill. The first one has to do with the definition of state in 138005 that's been updated in section 32 of the bill. And I don't know the answer to the question, but I just am concerned about whether or not there are other consequences of changing that definition in that chapter for these purposes. So no answer needed for me, but yeah, just wanted to raise that.
That's good to double check, and I'm sure Jessica and Legislative Council will look into that, as well as if anyone else has any thoughts on that, please let us know. And then the final one on your list.
Yeah, the final one on the list has to do with the jurisdictional requirements regarding service in criminal appeals. section 34, I believe it was subsection 2. And I just, again, was clarifying the intent of the work group, because it seems like that wording change would apply to all appeals and not just appeals that are coming from local courts that go through the circuit court into the Court of Appeals. And I just, again, wanted to confirm my reading of that change to 138081. And I think maybe that's a change in the law, but again, I'm not 100% sure on that.
Can I clarify the question? I'm sorry.
Yeah, I'm sorry.
So we're talking about the concern, if I'm understanding correctly, is that that by amending 138081, it would apply to appeals that are coming out of the local court, not just appeals coming from circuit court to the Court of Appeals. Was that the issue?
No, my question is whether or not this is affecting the jurisdictional, just whether or not it affects all appeals to the Court of Appeals and not just the scope of the appeals that we were talking about in this work group, and whether or not this is a change in the law for all appeals, that service is not a jurisdictional requirement.
I think that would affect all, right? Because that chapter pertains also to like cases originating in circuit court.
I think that's a good point, because subsection 2, I think we were intending for that to apply to the local courts, if I'm recalling correctly. Subsection 2 specifically, but it doesn't say that in here.
So I think if the intent is only to apply to these appeals that we've been reviewing here in the work group, then the wording might need to be changed.
Well, I don't know that it would only, I mean, I think it could also apply to, for instance, violation cases that are heard by the circuit court in the first instance. You still have the same situation where the prosecution is represented by the citing officer, but on appeal under the current law and under the bill, service should be on the district attorney or the county council, you know, or the city attorney, depending upon which entity adopted the offense. So I think it would apply to all violations, but I think some thought needs to be given whether it might also apply to felonies and then misdemeanors where it shouldn't. So that's something I would be willing to take a look at.
Although the likelihood of like incorrect service for cases where individuals are represented would probably, well, I'm just assuming public defenders. I always have like indigent folks in mind, but maybe a lot less likely in those cases to have mistaken service than in a violation case. Sorry, Jimmy, I think I spoke up.
Sure, I would say, I mean, this is taking something that to this point has been jurisdictional and is making it not jurisdictional seems to be doing it in all appeals. So that's a choice that we're making. I'm not entirely sure why. I would imagine that the reason is we're taking it from a rule that you need to serve the district attorney, except a pretty small class of cases, and turning it into, well, it's one of these 3 choices, and that's potentially more difficult. So that might be a reason you'd want to make it not jurisdictional, or not jurisdictional as long as you at least serve one of the 3, even if it's the wrong one. Although I'm not sure that makes a lot of sense. So I think that is a major change. Well, major as far as these things go, but a change that's being made.
I mean, it's not that major of a change because in juvenile cases and post-conviction relief cases, we have a very similar provision. And the reason we have it in there is that often service on the proper representative of the state happens after the 30 days because typically the party is represented by different appointed counsel on appeal, and the appointment of counsel and proper service sometimes doesn't happen until after the 30 days has run. So the legislature has long since made a policy decision that it's not going to penalize the appellant in that situation for faulty or untimely service simply because of the mechanics of getting appellate counsel. But I think it's worth reviewing the statute, making sure what we're doing and that we're not substantially changing the law here.
You're saying you don't think this is a substantial change?
No, I don't know. I don't think it is.
Heather?
I just was thinking about Jimmy's comment and recalling the conversations that I think informed this provision, that there were new requirements or changed requirements around service that were more complicated, what entity is the proper one to serve. And so I think this was intended to provide a little flexibility, recognizing that, pro se litigants in particular may have some difficulty navigating that or confusion. And, I don't think the intention was to affect appeals originating in circuit court. But my sense is, even if it did, it's not clear to me that this is really such a significant change. It's merely authorizing the Court of Appeals to extend the time of service, where the Court of Appeals finds it proper. And so, and I think that even though we were mainly concerned about pro se litigants, in local courts, there are pro se litigants in these other courts. I know that wasn't like our main focus of this work group, cases arising out of circuit court, but my sense is that some of that flexibility could be beneficial to other parties as well. So I would advocate for just leaving it.
I think that also that depending on how we end up, it should be, explicitly stated in the report, probably on what the change to the law is.
Okay, well, I think that we'll talk about it in the leadership group. And it doesn't sound like people have a strong preference. I guess you can communicate with us if you do, but obviously it needs to be clear. Okay, I see Jessica's note that confirming that the conditional plea transfers in section 5 sub 2 have applied to violations since the first proposal. So I guess we need to wrap up the discussion on the filing fee there. It's sort of
We can add a filing fee.
Okay, Jimmy thinks we should add a filing fee. Anybody else?
I don't think there should be a filing fee, but I think that we're probably out of time to have a deep dive into that discussion.
I appreciate that realistic assessment. Anyone opposed to adding a filing fee as there would be with an appeal for a violation? Tony, did you want to say anything?
No, I'm just opposed. And I should say something in support of that, but if it's a if it smacks of a criminal case, some of the violations that I've seen really are misdemeanors, but they're not called that. I've seen prosecutors charge things as violations because they wanted a lower burden of proof to apply, but they have significant consequences to the defendant. So, and name their violations, but in fact, they're sometimes misdemeanors. So I'd like to see anything that smacks of, I'll use that term, criminal, which I think violations do in many instances. Maybe it's not so much traffic, but under city codes, they sometimes become really misdemeanors in disguise. So I'm against a filing fee.
I think we've discussed about filing fees in general for violation cases and decided we weren't able to come to a decision to change those at this point. Maybe that's something the group would like to take up further in the future and think about whether there's changes that could happen. But Heather, did you want to make any more comments?
Just that, that's the kind of policy discussion we were having previously, and I agree wholeheartedly with it, what Tony was saying, and just wondering whether that is also something that could be noted in the report. If there are going to be policy issues flagged, that I think there was a bit of discussion about that before, and it'd be a good one to flag.
I don't have any objection to flagging it in the report as a policy question that we weren't able to make changes on. That might be good for future discussion. Does anyone else have any trouble with or difficulty with us putting that in the report? And then go ahead and for now, adding the filing fee to the transfer for violations. Okay, I really appreciate you all sticking around almost an extra half hour here. This has been super helpful. And again, another 24 hours to send us further comments, and we will do our best to get an edited draft that reflects what everybody has discussed here. It has been a pleasure working with you, and we will continue to be in touch, doubtless, as these things go on. I don't know if we'll need to schedule any in-person meetings. We'll see what happens. Any further questions or comments? Okay, I'm going to let you go finally. Thank you.